Good afternoon, and thank you for joining us today. My name is Julie Leclerc. I'm an executive manager in FINTRAC's supervision sector. I'm pleased to welcome you to the FINTRAC webinar, Follow the Money, Sanctions Evasion, Property Reporting, and the Fight Against Illegal Fentanyl Financing. Please note that this session will be recorded. Today's session will cover important topics, including your compliance obligations and reporting requirements relating to sanctions evasions and sanctioned property, and FINTRAC's new report called Listed Persons and Entities Property Report, or the LPEPR. Before we begin, I'd like to take a moment to acknowledge that FINTRAC operates on the traditional, unceded territories of Indigenous peoples across Canada. We recognize and respect their ongoing relationship with this land. The goal of today's session is to give you a clear understanding of the reporting obligations relating to sanctions with the coming into force of the listed person or entity property reporting requirements on March 2nd, 2025, and its next phase, which will be on October 1st, 2025. In this session, we will be providing a brief overview of Canada's sanctions regime and stakeholders. We will go over the existing reporting obligations on sanctions evasion. We will introduce the reporting obligations on sanctioned property. We will outline compliance expectations for reporting entities, and we will highlight the resources FINTRAC has for REs. So in terms of Canada's sanction regime, a sanctions evasion offense means an offense arising from the contravention of a restriction or prohibition established by an order or regulation made under the United Nations Act, the Special Economic Measures Act, or the Justice for Victims of Corrupt Foreign Officials Act. Like many other countries, Canada imposes sanctions on designated countries, specific individuals, and entities. Sanctions have become an increasingly important element in Canada's foreign policy toolkit and plays a crucial role in helping maintain and restore international peace and security, combating corruption, and promoting respect for human rights. Global Affairs Canada is responsible for the administration of Canada's sanctions under the United Nations Act, the Special Economic Measures Act, also known as CEMA, and the Justice for Victims of Corrupt Foreign Officials Act. The RCMP and the Canada Border Services Agency enforce these statutes and associated regulations. FINTRAC supports and ensures compliance with reporting requirements under the PCML-TFA and associated regulations, which includes reporting suspicious transactions where there are reasonable grounds to suspect the transaction is related to the commission or the attempted commission of a sanctions evasion offense, and since March 2nd, 2025, sanctioned property. FINTRAC develops strategic intelligence products and discloses financial intelligence in support of law enforcement and the implementation of Canada's sanctions regime. Sanctions are set to help safeguard financial systems and reduce the risk of international threats to Canada and its allies. It is the responsibility of all persons in Canada and Canadians abroad to comply with Canada's sanctions regime. Now, who must comply? Canadian sanctions place restrictions on the activities permissible between persons in Canada or Canadians outside Canada and foreign states, individuals, or entities. They can target specific countries, organizations, or individuals, and can encompass a variety of measures, including restricting or prohibiting trade, financial transactions, or other economic activity between Canada and the target state or its enablers. Persons in Canada and Canadians abroad, including Canadian financial institutions and businesses, are responsible for complying with sanctions and are obligated to continuously monitor their accounts and transactions for assets linked to listed persons. In instances where those assets are identified, they are to be effectively frozen as a result of the dealings ban prohibitions, and their existence disclosed to the RCMP or CSIS and/or a designated regulatory body such as FINTRAC. Canada's 2023 Fall Economic Statement announced the government's commitment to introduce legislative measures to combat sanctions evasion. These measures allow FINTRAC to use its expertise, empowered by the PCML-TFA, to develop intelligence products and, where appropriate, disclose its findings to law enforcement partners in an effort to support law enforcement and Canada's sanction-based asset seizure and forfeiture regime. As of June 2024, FINTRAC has the authority to disclose financial intelligence related to sanctions evasion to the appropriate law enforcement agencies. As of August 19, 2024, in addition to the long-standing obligation to report transactions where there are reasonable grounds to suspect that they are related to a money laundering or terrorist activity financing offense, reporting entities must report transactions suspected to be related to sanctions evasion to FINTRAC. These transactions are required to be reported using FINTRAC's Suspicious Transaction Report form. When a reporting entity reaches reasonable grounds to suspect that a transaction is linked to a sanctions evasion offense, this transaction may be related to the prohibitions in sanctions related to the provision of financial services, but may also link to other prohibitions linked to trade. For example, Russia oil price cap. FINTRAC has published a special bulletin on financial activity associated with sanctions evasion, as well as guidance on reporting suspected sanctions evasion for reporting entities to comply with the new reporting requirement. These include characteristics of transactions related to sanctions evasion that can be leveraged. As a result of legislative and regulatory changes, the Terrorist Property Report has been enhanced to include the requirement for REs to report to FINTRAC when they must disclose to CSIS or the RCMP on sanctioned property. The name of the report has changed from Terrorist Property Report to the Listed Person or Entity Property Report. The reporting obligation has come into force over 2 dates. The original terrorist property reporting requirements set out to track and report on the movement of terrorist property that we need to monitor for the safety and security of our financial ecosystem. With the new listed person or entity property reporting requirements, the TPR has evolved into the LPEPR. The LPEPR has a broader range of abilities, including now able to detect property not only owned or controlled by terrorists, but also by sanctioned persons or entities. Since March 2nd, 2025, reporting entities are required to report property owned or controlled by persons and entities under an order or regulation made under the United Nations Act. This is in addition to the long-standing obligation with respect to property owned or controlled by a terrorist group, as defined in the Criminal Code, or a listed person as defined in the regulations implementing the United Nations Resolution on the Suppression of Terrorism. As of October 1st, 2025, reporting entities will be required to report property owned or controlled by persons and entities under an order or regulation made under the Special Economic Measures Act and Justice for Victims of Corrupt Foreign Officials Act. On February 28, 2025, FINTRAC published the updated LPEPR guidance and reporting form. The reporting form remains a fillable PDF to be submitted by fax or by mail. As shown on the timeline slide, the reason for the 2 coming into force dates is that the reporting requirement changes twice. As part of these changes, we have introduced a new definition for listed person or entity in the PCML-TF-STR regulations, which I will detail here to help visualize the reason for the 2 coming into force dates. On March 2nd, 2025, the definition of listed person or entity was introduced, replacing the listed person definition to include a terrorist group as defined in the Criminal Code, a person or entity subject to an order or regulation made under the UN Act, This includes the regulations implementing the UN resolutions on the suppression of terrorism, and foreign states subject to an order or regulation made under the UN Act. On October 1st, 2025, the definition will change again to include a foreign state subject to an order or regulation made under CIMA, a person or entity subject to an order or regulation made under CIMA, and a person who is a subject of an order or regulation made under the Justice for Victims of Corrupt Foreign Officials Act. The introduction of this new term and definition is very important for REs to be aware of. And I do want to emphasize that while the term is listed person or entity, a terrorist group as defined in the Criminal Code may be a listed entity by Public Safety Canada, but could include cases where a reporting entity comes across information that leads them to determine that a client is associated with or is part of a terrorist group, for instance, through media, publicly available information, or other official lists. In these cases, the terrorist group may not be listed, but does fall under the definition of a listed person or entity. By terrorist group, we mean an entity that has one of its purposes or activities facilitating or carrying out any terrorist activity, or a listed entity, and includes an association of such entities. Now, as we look to compliance expectations for reporting entities, REs may have previously treated their obligations under the PCML, TFA, and associated regulations as separate from their obligations to comply with sanctions, but the legislative and regulatory changes have introduced opportunities that a more holistic approach be taken. As a result of the requirement to include suspicions of a sanctions evasion offense, FINTRAC has published guidance on reporting on sanctions evasion and updated the suspicious transaction report to include sanctions evasion as a suspicion type. As for the new LPEPR reporting requirements, FINTRAC has published updated guidance and the reporting form for the LPEPR to assist reporting entities in complying with their obligations. Now, looking at the compliance officer obligation, appointed compliance officers should have knowledge of sanctions evasion risks and sanctions evasion trends and typologies, and are responsible for updating the compliance program to integrate sanctions evasion and sanction property reporting obligations. For the policies and procedures, REs must update their policies and procedures to capture the expansion of the reporting requirement for listed person or entity property report, and to consider the characteristics of a sanctions evasion offense for STR reporting. Policies and procedures should cover how the reporting entity will become aware of sanctions. Reporting entities will need to ensure their screening and monitoring procedures capture the sanctions lists that apply. The Consolidated Canadian Autonomous Sanctions List is available to search names. This list includes individuals and entities subject to specific sanctions regulations made under CIMA and the Justice for Victims of Corrupt Foreign Officials Act. The United Nations Security Council Consolidated List provides a list of entities subject to measures imposed by the United Nations Security Council under the United Nations Act. FINTRAC's guidance includes references to lists of individuals and entities subject to sanctions. Still, sanctions are subject to change without notice. Therefore, reporting entities are encouraged to consult the Global Affairs Canada website for the most up-to-date information and regulations. Now, moving on to the training program. Reporting entities training program should identify characteristics of a sanctions evasion offense and how their business or profession could be vulnerable. Additional training may be needed for employees whose roles and responsibilities are related to detecting and deterring money laundering, terrorist financing, and sanctions evasion offenses, and when dealing with potentially suspicious activities or transactions. The training program and plan should be tailored to the business's size, structure, and complexity, and its degree of exposure to money laundering, terrorist financing, and sanctions evasion risk. Now for the risk assessment. REs must continue to assess their risks by considering the prescribed factors. FINTRAC's risk assessment guidance already included expectations for reporting entities to consider high-risk countries, including those subject to economic sanctions, embargoes, or other measures. There are some common observed indicators to look out for when assessing if a transaction is at risk of attempting to evade sanctions. This can include, but is not limited to, the use of intermediary jurisdictions, the evasion of import and export controls, the use of opaque corporate structures, non-resident banking, the use of proxies and enablers, and the use of virtual currencies or other financial channels. As part of the process of reporting suspicious transactions related to the commission of a sanctions evasion offense, businesses must actively monitor and identify transactions and risks related to sanctions evasion. Transactions where there are reasonable grounds to suspect that a money laundering, terrorist financing, or sanctions evasion offense has occurred must be reported to FINTRAC. These transactions are required to be reported using FINTRAC's Suspicious Transaction Report form. Reasonable grounds to suspect is the required threshold to submit a STR to FINTRAC and is a step above simple suspicion, meaning that there is a possibility that a money laundering, terrorist financing, or sanctions evasion offense has occurred. You do not have to verify the sanctions evasion indicators that led to your suspicion, nor do you have to prove that a money laundering, terrorist financing, or sanctions evasion offense has occurred in order to reach this threshold. Your suspicion must be reasonable and therefore not biased or prejudiced. Reaching this threshold means that you've considered the facts, the context, the money laundering or terrorist financing indicators, and the sanctions evasion characteristics related to a financial transaction. These suspicious transactions reports are critical to FINTRAC's ability to develop and disseminate financial intelligence. Now, looking at ministerial directives, reporting entities must also comply with ministerial directives. Under Part 1.1 of the PCML-TFA, the Minister of Finance may issue directives that require reporting entities to apply countermeasures to transactions coming from or going to designated foreign jurisdictions or entities, and recommend the introduction of regulations to restrict reporting entities from entering into a financial transaction coming from or going to designated foreign jurisdictions or entities. These authorities allow the Minister of Finance to take steps to protect the integrity and reputation of Canada's financial system from foreign jurisdictions and foreign entities that are considered to present high risks for facilitating money laundering, terrorist financing, sanctions evasion, or financing of threats to the security of Canada. They include countermeasures for reporting entities that enhance or add to existing obligations. Currently, ministerial directives are in force with respect to 3 jurisdictions, also subject to Canadian sanctions: the Democratic People's Republic of Korea, the Islamic Republic of Iran, and Russia. Now, how to report to FINTRAC. When reporting a financial transaction to FINTRAC, all information that helps identify the transaction as suspected sanctions evasion activity should be included. This includes detailing information related to the products and/or services involved in the suspicious transactions, including the accounts and addresses involved, particularly if they are linked to jurisdictions associated with the facilitation of financial flows from sanctioned jurisdictions. Reporting entities should continue to include any information on the ownership, control, and structure of entities involved in transactions, such as listing the owners, directors, officers, and those with signing authority, as well as any information about related persons or entities involved where possible. Reporting entities should also include all available identifying information and descriptions of any legal entities or arrangements involved or associated with the financial transactions. FINTRAC will assess compliance through supervisory assessment activities, such as case file review related to reporting requirements and identification of unreported STRs. If a transaction is suspected of being related to both a money laundering, terrorist financing offense, and a sanctions evasion offense, one report containing details and all required information of each of the suspected offenses should be submitted. FINTRAC has added sanctions evasion values to the STR report. Under suspicion type, you may now select money laundering, terrorist financing, money laundering and terrorist financing, sanctions evasion, money laundering and sanctions evasion, terrorist financing and sanctions evasion, or money laundering, terrorist financing, and sanctions evasion. In cases where the primary suspicion type is sanctions evasion, businesses will have two options to report. Businesses with system capability to select the new sanctions option can select the primary suspicion type from the drop-down list. REs with no system capability at this time to select new sanctions options must select money laundering value from the drop-down list and add hashtag sanctions as the grounds for suspicion in the description of suspicious activities section. This section was previously referred to as the Part G before the reports were updated. FINTRAC has already received some STRs related to sanctions evasion, so we thank you for that. As the listed person or entity property report is replacing the terrorist property report, it is to be submitted the same way, either by fax if the reporting entity has electronic capabilities, or by mail. Now on the fight against illegal fentanyl financing. The Prime Minister issued the Directive on Transnational Crime and Border Security. This directive acknowledged the urgent threats that the international and domestic drug trades, including the traffic of fentanyl, pose to the livelihoods and safety of Canadians, as well as the role that organized crime groups and money laundering play in driving these threats. These changes will strengthen border security by giving the CBSA the authority to detect, deter, and disrupt illicit financial activities conducted through trade. By requiring traders to declare that their imported or exported goods are not linked to money laundering, terrorist financing, or sanctions evasion, the CBSA will be better equipped to identify and prevent financial crimes that exploit trade channels. The illegal production and distribution of synthetic opioids, particularly fentanyl, poses a serious security and public health threat by exacerbating the opioid overdose crisis. Criminals are laundering their illicit funds from opioid trafficking through cash smurfing, trade-based money laundering, flow-through account activity, and the use of underground banking. Traffickers also use nominees to launder their illegal funds and to conceal the beneficial ownership. The ability to compel supporting documents and enforce penalties for non-compliance will enhance regulatory oversight, closing loopholes that previously allowed criminals to move illicit funds across the Canada-US border undetected. These measures will strengthen cross-border enforcement, combat trade-based money laundering, and improve overall financial and national security. FINTRAC continues to issue guidance to reporting entities. We've published guidance on reporting suspected sanctions evasions and on the listed person and entity property report. We also published the new LPEPR form. FINTRAC's Strategic Intelligence Analysis developed a special bulletin that that has been published on financial activity associated with suspected sanctions evasion. And now in terms of key takeaways, a sanctions evasion offense occurs when someone violates a restriction or prohibition under the United Nations Act, the Special Economic Measures Act, or the Justice for Victims of Corrupt Foreign Officials Act. Since August 19, 2024, reporting entities must report STRs, suspicious transactions report, related to suspected sanctions evasion offenses. Since March 2nd, 2025, reporting entities must report listed person or entity property reports linked to the United Nations Act. And as of October 1st, 2025, reporting entities will need to report a listed person or entity property report linked to the Special Economic Measures Act or the Justice for Victims of Corrupt Foreign Officials Act. Now, this concludes our information session. I hope that the information was useful. You will be receiving a short survey. If you could please take a few minutes to fill it out. Thank you very much and wishing everyone a wonderful afternoon.